Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
But the problem is that they are making the rest of us pay for it, because as much as they say, well, we're not in the market, we don't know when the time and when they will be, and the figures that how much more families are paying for insurance because people get sick, they may have intended to self-insure, they haven't been able to meet the bills for cancer, and the rest of us end up paying because people are getting cost-free health care. And the only way to prevent that is to have them pay sooner rather than later, pay up front.
Yes, but my point is this, that, with respect, Justice Ginsburg, conflicts the people who do result in uncompensated care, the free riders. Those are people who default on their health care payments. That is an entirely different group of people, an entirely different activity than being uninsured. So the question is whether or not you can regulate activity because it has a statistical connection to an activity that harms commerce. And my basic point to you is this. The Constitution only gives Congress the power to regulate things that negatively affect commerce or commerce regulation. It doesn't give them the power to regulate things that are statistically connected to things that negatively affect commerce. I'm sorry.
Please.
I was just going to say, because if they have that power, then they obviously have the power to regulate everything, because everything in the aggregate is statistically connected to something that negatively affects commerce, and every compelled purchase promotes commerce.
So in your view right there, in your view right there, I'm just picking on something I'd like to just, if it turned out there was some terrible epidemic sweeping the United States, and we couldn't say that more than 40 or 50%, I can make the number as high as I want, but you'd say the federal government doesn't have the power to get people inoculated, to require them to be inoculated, because that's just statistical.
Well, in all candor, I think Morrison must have decided that issue, right? Because people who commit violence...
Is your answer to that yes or no?
Oh, I'm sorry. My answer is no, they couldn't do it. Because
no, they could not do it. They cannot require people, even if this disease is sweeping the country, to be inoculated. The federal government has no power, and if there's terror... okay, fine. Go ahead. Please turn to Justice Kagan.
May I just please explain why? Yeah. Violence against women obviously creates the same negative impression on fellow citizens as this communicable disease. And it has huge effects on the health care of our country. Congress found that it increased health care costs.
I agree with you that it had big effects, but the majority thought that was a local matter.
Now I think that's his point. I don't know why having the disease is any more local than beating up a woman, but my basic point is that, notwithstanding its very profound effect on the health care market, this Court said the activity being regulated, i.e. violence against women, is outside the Commerce Clause power. So regardless of whether it has beneficial downstream effects, we must say no, Congress doesn't have that power. Why not? Because everything has downstream effects on commerce, and every compelled purchase promotes commerce. It by definition, helps the sellers and existence.
Mr. Carbon, isn't there this difference between Justice Breyer's hypothetical and the law that we have before us here? His hypothetical, the harm to other people from the communicable disease is the result of the disease. It is not the result of something that the government has done. Whereas here, the reason why there's cost shifting is because the government has mandated that. It has required hospitals to provide emergency treatment, and instead of paying for that through a tax, which would be borne by everybody, it has it has set up a system in which the cost is surreptitiously shifted to people who have health insurance and who pay their bills when they go to the hospital.
Justice Alito, that is exactly the government's argument. It's an extraordinarily illogical argument.
Fine, then, if that's so, let me just change my example under pressure and say that, in fact, it turns out that 90% of all automobiles driving interstate without certain equipment put up pollution which travels interstate, not 100%, maybe only 60%. Does the EPA have the power then to say, you've got to have an anti-pollution device? It's statistical.
What they can't do, yes, if you have a car, they can require you to have an
Then you're not going on statistics. You're going on something else, which is what I'd like to know what it is.
It's this. They can't require you to buy a car with an anti-pollution device. Once you've entered the market and made a decision, they can regulate the terms and conditions of the car that you do, and they can do it for all sorts of reasons. What they can't do is compel you to enter the market.
Now we understand. And then you've changed the ground of argument, which I accept as totally legitimate. And then the question is, when you are born and you don't have insurance and you will, in fact, get sick and you will, in fact, impose costs, have you, perhaps involuntarily, perhaps simply because you are a human being, entered this particular market, which is a market for health care?
If being born is entering the market, then I can't think of a more plenary power Congress can have, because that literally means they can regulate every human activity from cradle to grave. I thought that's what distinguished the plenary police power from the very limited commerce power. I don't disagree that giving the Congress plenary power to mandate property transfers from A to B would be a very efficient way of helping B and of accomplishing Congress's objective.
I see the
but
point.
The framers,
you go back to Justice Kagan. Don't forget her question.
I've forgotten my question.
I was facing the same dilemma, Justice Kagan.
Well, let me ask you a question that I asked Mr. Clement. It just seems...
That's what it means to be the junior justice.
Years.
Right, so I'll tell you this number, which I did look up, that the amount approximately, if you look into it, as a percentage of GDP, it's big. But it was, before this, somewhere about 2-point-something% fairly low of GDP. It'll go up to something a little bit over 3% of GDP. And now go look at the comparable numbers, which I did look at, with the expansion that we're talking about before. The expansion from 0 to 18, or even from 0 to 6. And while you can argue those numbers, it's pretty hard to argue that they aren't roughly comparable as a percentage of the prior program or as a percentage of GDP. If I'm right on those numbers, or even roughly right, I don't guarantee them, then would you have to say, well, indeed, Medicaid has been unconstitutional since 1964. And if not, why not?
The answer is no, and that's because we're here saying there are three things that make the statute unique.
What are your second and third? I'm on pins and needles, Steve.
Yeah, exactly. Well, one is the sheer size. Two is the fact that this statute uniquely is tied to an individual mandate, which is decidedly non-voluntary. And three is the fact that they've leveraged the prior participation in the program, notwithstanding that they've broken this out as a separately segregated fund going forward, which is not true.
So on the third, suppose you have the current program and Congress wakes up tomorrow and says, we think that there's too much fraud and abuse in the program, and we're going to put some new conditions on how the states use this money so we can prevent fraud and abuse, and we're going to tie it to everything that's been there initially. Unconstitutional?
No, I think that is constitutional because I think that's something that Congress could do directly. It wouldn't have to limit that to the spending program. I think 18 U.S.C. 666 is a statute, it's in the criminal code. It may be tied to spending, but I think that's a provision that I don't think it's constitutional, at least called into question.
I guess I don't get the idea. I mean, Congress can legislate fraud and abuse restrictions in Medicaid, and Congress can legislate coverage expansions in Medicaid.
Well, Justice Kagan, I think there's a difference. But if I'm wrong about that, and the consequence is that Congress has to break Medicaid down into remotely manageable pieces, as opposed to $3.3 trillion over 10 years before the expansion, I don't think that would be the end of the world. But I really would ask you to focus on specifically what's going on here, which is they take these newly eligible people, and that's a massive change in the way the program works. These are people who are healthy, childless adults who are not covered in many states. They say, okay, we're going to make you cover those. We're going to have a separate program for how you get reimbursed for that. You get reimbursed differently from all the previously eligible individuals. But if you don't take our money, we're going to take away your participation in the program for the visually impaired and the disabled, if I may reserve the balance of my
Well, I'm not sure my colleagues have exhausted their questions, so.
My greatest fear, Mr. Clement, with your argument is the following. The bigger the problem, the more resources it needs. We're going to tie the hands of the federal government in choosing how to structure a cooperative relationship with the states. We're going to say to the federal government, the bigger the problem, the less your powers are. Because once you give that much money, you can't structure the program the way you want. It's our money, federal government. We're going to have to run the program ourselves to protect all our interests. I don't see where to draw that line.
Well,
the uninsured are a problem for states only because they too politically, just like the federal government, can't let the poor die. And so to the extent they don't want to do that, it's because they feel accountable to their citizenry. And so if they want to do it their way, they have to spend money to do it their way. If they don't want to do it the federal way. So I just don't understand the logic of saying states, you're not entitled to our money, but once you start taking it, the more you take, the more power you have.
Well, Justice Sotomayor, a couple of points. One is, I actually think that sort of misdescribes what happened with Medicaid. I mean, states were, as you suggest, providing for the poor and the visually impaired and the disabled even before Medicaid came along. Then all of a sudden the federal government says, look, we'd like to help you with that, and we're going to give you money voluntarily. And then over time, they give more money with more conditions, and now they decide they're going to totally expand the program, and they say that you have to give up even your prior program where we first came in and offered you cooperation. We're now going to say you have to give that up if you don't take our new conditions. Secondarily, I do think that our principle is not that when you get past a certain level, it automatically becomes coercive per se. But I do think when you get a program and you're basically telling states that, look, we're going to take away $3.3 trillion over the next 10 years, that at that point it's okay to insist that Congress be a little more careful that it not be so aggressively coercive as it was in this statute. And I would simply say that we're not here to tell you that this is going to be an area where it's going to be very easy to draw the line. We're just telling you that it's exceptionally important to draw that line. And this is a case where it ought to be easy to establish a beachhead, say that coercion matters, say there's three factors of this particular statute that make it as obviously coercive as any piece of legislation that you've ever seen, and then you will have effectively instructed Congress that there are limits, and you have laid down some administrable rules.
Mr. Clement, the Chief has said, I can ask this.
He doesn't always check.
As I recall your theory, it is that to determine whether something is coercive, you look to only one side, how much you're threatened with losing or offered to receive, and the other side doesn't matter. I don't think that's realistic. I mean, I think, you know, the old Jack Benny thing, your money or your life, and, you know, he says, I'm thinking. It's funny because it's no choice. You know, your life, again, is just money. It's an easy choice. No coercion. Right? I mean, right? Now, whereas, if the choice were your life or your wife's, that's a lot harder. Now, is it coercive in both situations?
Well, yes, it is.
Really?
I mean,
it's a tough choice in the
I thought you were going to say this statute is your money and your life.
Yeah, well, and it is, but I mean,
Which way?
I might have missed something, but both of those seem to be the
No. To say when you say you're coerced, it means you've been given an offer you can't refuse. Okay, you can't refuse your money or your life, but your life or your wife's, I could refuse that one.
Clemente, he's not going home tonight.
Let's eat the wine count. Saying it the
I
other
was going
way.
to say, Mrs. Clement.
So I'm talking about my life. I'd say, take mine, you know.
I wouldn't.
Let me use that example. Forget about it.
It's enough frivolity for a while. But I want to make sure I understand where the meaningfulness of the choice is taken away. Is it the amount that's being offered, that it's just so much money, of course you can't turn it down? Or is it the amount that's going to be taken away if you don't take what they're offering?